let me introduce Tom first. Since October 2009, Tom Perez has led the Department of Justice's Civil Rights Division, which was created in 1957 to uphold the civil and constitutional rights of all Americans. As the head of this division, Tom oversees its Special Litigation Section, which is responsible for the enforcement of a variety of federal civil rights statutes, including RLUIPA. Tom has spent his entire career in public service. Prior to his nomination by President Obama, he served as the Secretary of Maryland's Department of Labor, Licensing, and Regulation, and was a principal architect of a sweeping reform package to address his state's foreclosure crisis. In 2002, he was elected to the Montgomery County Council. He was the first Latino ever elected to the council, and he served as its president in 2005. Tom also previously served as special counsel to the late Senator Edward Kennedy, who was a primary Senate co-sponsor of RLUIPA, along with his colleague, Senator Orrin Hatch. Tom, we're so grateful that you could be with us today, and we also want to recognize that you brought some of your excellent staff with you today. And I want to mention the name of Eric Treen, who has been a longtime friend and has done such excellent work on these issues. So Tom, thank you for being with us. We welcome you to speak to us.
Thank you. Good afternoon. It's great to see you all, and it's great to see so many friendly and familiar faces who have been involved in so many critical issues of inclusion and tolerance and respect. And so I want to welcome all of you and say thank you for inviting me. Carolyn Fredrickson is a wonderful leader at ACS, and you put on so many critically important events. And so I want to again commend ACS for their wonderful work. You mentioned Eric, and I also want to mention my colleague Mazen Basrawi. Eric and Mazen are co-leaders of a wide array of efforts in our division to ensure not simply enforcement of our RLUIPA, but a wide array of outreach, enforcement, education activities relating to religious liberty, religious tolerance, and inclusion. And so we're very fortunate to have both Eric and Mazen and Esma, who is also with us today as well. And I also want to note that we do have our 10-year report in the back of the room, which highlights the work, the bipartisan work that has been done. The nonpartisan work really is a more accurate term that has been done over the last 10 years in this area. And the timing of this anniversary is really auspicious because it really provides us with an opportunity to reflect on the values of our nation and the protections of our basic rights at a time when the national conversation about these issues has produced a great amount of heated rhetoric. And I want to thank, there's a number of people in the audience who came to a meeting recently with the Attorney General, and it was a very eclectic group of leaders from the faith communities across our country, and we were there to discuss how we respond to a recent spate of very, very troubling incidents. And the Attorney General said then, he's reiterated since then, and we will continue to reiterate with regularity this administration's absolutely dogged commitment to using every tool in our law enforcement arsenal to protect religious liberty and to combat hate-fueled violence, and we will continue to do that. And our RLUIPA was response, again, by a bipartisan coalition of members of Congress, and I want to, again, say thank you to Chairman Nadler and former Congressman Kennedy on the House side, and to my former boss, Senator Kennedy, and Senator Hatch on the Senate side for co-sponsoring this very, very important piece of legislation. As Senators Hatch and Kennedy said in their joint statement upon the passage of the bill, the right to assemble for worship is at the very core of the free exercise of religion. And that this bill was co-sponsored by two people who are, shall we say, ideologically from different perspectives from time to time, is a real tribute to the fact that this issue is not about Democratic or Republican values. They are really about American values, and they are at the very core of our nation's existence. And there is perhaps, in my judgment, no greater precondition for the exercise of religious freedom than the ability to worship and to practice one's faith in peace. And yet throughout our history, members of various religious groups have faced discrimination, bigotry, hate, and regrettably, violence. And regrettably, those actions continue today. Just a few months ago, we indicted a 24-year-old Alabama man for his role in vandalizing a synagogue in Mobile with neo-Nazi markings. Just 2 days before we announced that indictment, a 22-year-old Massachusetts man became the second person to plead guilty relating to the burning of a predominantly African-American church in Springfield on the morning after President Obama was elected. And they did that because they were angry that America had the audacity to elect an African-American president. And this spring, a third person, the third of three, was sentenced in connection with a arson of a mosque in Tennessee. And so we see, whether it's manifested very overtly through these acts of violence, or in other ways through the defacement of property or hateful rhetoric, or through, in subtle fashions, discriminatory land use and zoning policies, barriers to religious liberty are indeed a threat to our freedom and to our nation's identity. Time after time, leaders have recognized these barriers and acted to break them down. They wrote religious freedom into our Constitution, and they backed it up by including religion in the Civil Rights Act of '64, and then a few years later, when Congress passed the Fair Housing Act and the Hate Crimes Bill in '68, it was again written in. Fast forward to 1996, and I see my friend Michael Lieberman and others who were once again out there working in a bipartisan fashion to respond to the spate of church arsons and the passage of the Church Arson Prevention Act. Once again, another bipartisan and very strongly bipartisan act of Congress to address challenges of religious liberty. And 10 years ago, after a series of hearings that many of you were involved in, revealed the troubling truth that religious institutions, particularly minority religions or churches dominated by ethnic minorities, frequently faced both overt and subtle discrimination in land use, zoning, and elsewhere. And as a result, RLUIPA was passed. And in the decades since it has been added to the Civil Rights Division's arsenal of tools in our law enforcement capacities, RLUIPA has been used to protect the rights of people from a wide variety of faiths in a wide variety of contexts. Our investigations and cases have defended the rights of Jews, Muslims, Christians, Sikhs, Buddhists, and others. We've protected places of worship, religious schools, prayer groups in private homes, and critical social services such as homeless shelters, group homes, and soup kitchens. Just last week, we filed a case against the city of Walnut, California, alleging that the city had violated RLUIPA when it denied a conditional use permit to a Buddhist house of worship. Until the city denied the permit in January of 2008, it had not denied any conditional use permit to build, expand, or operate a house of worship since at least 1980. That was a long time. Months after the center's permit was denied, the city approved a permit for a Catholic church that, when completed, will be much larger than the Zen Center's proposed facility. This summer, we reached a settlement with the village of Suffern, New York, to permit a Jewish organization to operate a Shabbos house across the street from a local hospital. The village violated RLUIPA by refusing to permit the house to operate in the location, which is necessary in order for it to serve its core purpose. The house offers kosher meals and lodging free of charge to Orthodox Jews visiting family in the hospital on the Sabbath and on other holy days when they are required to refrain from driving, using electricity, and other activities. The settlement ensures that the house can continue to operate in the critical location near the hospital. In the decade since its passage, the Civil Rights Division has opened up 51 cases under RLUIPA, including 7 so far in 2010. We have filed 7 land use-related lawsuits, 10 amicus briefs in RLUIPA cases, and intervened in private lawsuits to defend RLUIPA's constitutionality in 30 land use cases. Many of our investigations have served to educate local officials about their obligations under RLUIPA and have led to change policies without litigation becoming necessary. We would rather educate than litigate whenever possible. These efforts to enforce RLUIPA are just one facet of a broader commitment to protecting the ability of communities to practice their faiths in peace. From prosecuting acts of violence against houses of worship to protecting the rights of individuals to be free from discrimination at school or in the workplace, we are vigilant in our efforts to combat barriers to religious liberty. And we will continue to be vigilant, whether it is in the land use context or whether it is in the institutions context. And we have a robust practice in both. And I said before, I believe this work is perhaps as important today as any time in our history. We have clearly made great progress in furthering civil rights, and our nation is far more tolerant than just a few decades ago. But I know if Senator Kennedy were here, and he is here in spirit, he would say that civil rights remains the unfinished business of America. And there are all too many people who continue to seek to divide our country along religious and other lines. We know, for instance, that in 2010, Muslim Americans continue to struggle for acceptance in many communities, and that was precisely why a very eclectic interfaith coalition came to meet with the Attorney General just a few days ago or a week ago. Of the 18 RLUIPA inquiries involving discrimination against Muslims that the department has initiated since 2001, 8 of those have been opened since May. And so we see a spike in our business, regrettably. I'd rather be that Maytag repairman waiting for the phone to ring, but regrettably I'm feeling a little more like the Toyota mechanic. And it really is a sober reminder that there are those in our nation who have not yet realized the full promise of equal opportunity and equal justice. And we know that it is our responsibility to stand up for them, to use the tools available to ensure that the protections of our Constitution are granted to all, and to continue to push forward so that our founders' vision of religious liberty can be realized by all. Let us not forget that our forefathers came to this land seeking freedom from religious oppression. I just took my kids to Philadelphia, and we saw the Liberty Bell, and they got another very firsthand understanding of why we fought that war. And it was about religious liberty. And we must honor that legacy, a legacy that has been around this nation since its inception, by ensuring that the United States can indeed continue to be the beacon of religious freedom. And you have our assurance that this Attorney General and this President will continue to use every tool in our arsenal to ensure protections of religious liberty. So thank you for marking this anniversary, Carolyn and others at ACS. Thank you to our distinguished panel, and thank you to those who have come today, because you are folks who have been in the front lines, making sure that these laws are given meaning, making sure that there is indeed full enforcement. And I want to thank Eric and my colleagues in the career staff of the Civil Rights Division, who have been vigilant in enforcing this law from day one. And we will continue to be vigilant in enforcing this law, because there are so many people who need our protection. Thank you very much, and I look forward to the rest of the presentation. Thank you.
Thank you so much, Tom. We're grateful for your time today. Thank you for being with us, and thank you to all the DOJ staff who are also with us. We're grateful for the work you do. I also want to introduce David Lockman, who will be speaking to us in just a moment. David Lockman is an old friend and Chief of Staff of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties of the House Judiciary Committee. And most importantly for our purposes today, David was one of the drafters and key movers of RLUIPA, and it was my pleasure to work with David in that capacity and many other capacities since. David works for Representative Jerry Nadler, who has already been mentioned, along with former Representative Charles Kennedy, were the key movers of RLUIPA in the House. And earlier today, I saw Kathy Cleaver-Roos. I believe she's here with us in the back. Thank you, Kathy. Kathy was working at the time for Representative Kennedy, and we're glad that she can be with us also today. So, David, we welcome you to come and speak to us. David is a great thinker and a great person to work with, and we're glad that you can be with us today to address RLUIPA 10 years later. Thanks, David.
Well, thank you for that. That was very gracious. I hope I can live up to that. And thank you to ACS. This is a very important occasion, and it reflects a great deal of work over time, especially by a lot of the people in this room who actually know much more about this than I do, so it's going to be a little nerve-wracking. But if I could, oh, and one thing you did omit, among his many accomplishments over the year, Tom Perez represented me in the Montgomery County Council. And as far as I'm concerned, yeah, absolutely. And he was wonderful. Anyway, what I'm going to try and do in a period of about 5 minutes is to set things up, how we got here from there, and then let our panel correct me. RLUIPA was really a response to a decision by the Supreme Court called Employment Division v. Smith, in which the court took what we had all thought was the rule, and depending on whom you believe, either tossed it aside or explained to us what the rule had actually been all along, and we just didn't know it. And Justice Scalia really did a service in that he managed to forge one of the great broad coalitions, probably one of the broadest we've ever seen here in Congress, ranging from the ACLU to the National Association of Evangelicals to some of the people on this panel who were essential in getting the work done. And it perhaps would be worthwhile remembering what Justice Scalia said that was so valuable to our work up here. In Smith, he said, it may fairly be said that leaving accommodation to the political process will place at a relative disadvantage those religious practices that are not widely engaged in, but that unavoidable consequence of democratic government must be preferred to a system in which each conscience is a law unto itself, in which judges weigh the social importance of all laws against the centrality of religious beliefs. We had a very crowded first meeting after that, and that gave rise to the Religious Freedom Restoration Act, which took several years to get through, but it really did bring a bunch of people together who really had spent a lot of time working at cross purposes on a number of issues. The unifying principle of the RFRA debate was precisely to take the free exercise rights of all Americans out of the referendum arena. That is, you don't have a show of hands. And not to go religion by religion, practice by practice, issue by issue. And it was really that response that underlay, and what RFRA tried to do was to restore what had been the rule, that is the application of strict scrutiny to instances in which government, in one way or another, has imposed a substantial burden on the free exercise of religion. Courts would weigh that in a balancing test to determine whether, in fact, the free exercise clause had been violated. It turns out the general rule is something everybody loves. As applied, not everybody is so thrilled. One of the biggest hurdles we faced in consideration of RFRA was the question whether somehow, if this were to pass and if the Supreme Court were to overturn Roe v. Wade, we were very sneakily creating a statutory right to abortion on the basis of religion. It's a long story. I didn't believe it either. But it managed to hold up the legislation for several years and basically took the election of a new president who was committed to signing it to get that through. Enter the Supreme Court again. I'm not going to delve into the Bernie decision because I think we have people here who may know something about it and will probably want to discuss it at length. But the court did hold that Congress had exceeded its powers with respect to the states in imposing the rule that we were attempting to, that is, imposing strict scrutiny. And incidentally, that goes not just for our little effort, but the legacy carries on in terms of our work in other civil rights areas, most specifically, for example, the Voting Rights Act, which we recently reauthorized and which was upheld, but which many people are concerned may have problems in the future. So it has broad implications beyond our little bill. So what was Congress to do? It was still good law at the federal level. It now did not apply to the states. So Congress returned to the drawing board to look at other powers, and specifically the spending power and the commerce power, with a bow in the direction of the 14th Amendment. Again, it attempted to, this would have been the Religious Liberty Protection Act, or RLUIPA to its friends, which attempted to once again make a run at what RFRA had done, using additional powers which the Constitution gives to Congress. That also encountered some resistance, and this time from the concern that it could and might very well be used as a way to find a religious exemption to existing civil rights laws. And that turned out to be a tremendous impediment, and one which gave rise to a compromise, which is what RLUIPA was. I'm messing up my acronyms again. Interestingly, in confining it to land use and institutionalized persons, Congress approached what had been, when we considered RFRA, a tremendous taboo. What about prison inmates? Would they be suing under this? Would that be a problem? Would this lead to all sorts of terrible litigation and the destruction of discipline and good order in the prisons? As a matter of fact, at the very end, the word substantially dropped into the language of RFRA. Substantially burden the free exercise of religion, and that was done primarily to reassure some remaining senators who were concerned that this would become open season in the prison system. There were other concerns as well, but that turned out to be a big one. So at the end, RLUIPA did get through. It did get, and it has been put to very good use. I think Tom Perez gave a very good discussion of that, and I'm sure we'll hear more. Chairman Nadler, in addition to chairing the Constitution Subcommittee, also represents Lower Manhattan, which is where the World Trade Center site was, where I think you do business, and where the project, which is not a mosque and is not at ground zero, is slated to be built. And in defense of my fellow New Yorkers, I would say that the further you get away from Lower Manhattan, the more vituperative the opposition becomes. You know, in terms of local elected officials and a lot of my former neighbors, the opposition, to the extent it is there, is not nearly as strong or widespread. There is, in fact, still great support for the radical notion that in America people get to pray, worship anywhere without the interference of government, no matter how many people don't like them at that particular moment. As I say, the general principle, one everybody loves. As a matter of fact, someone who many of us know who has litigated a lot of RLUIPA cases and who has talked a lot about RLUIPA over the years is now leading the charge in the courts against this cultural center. So it's a reason why we need the broader legislation, and we do need the courts standing guard outside of the political process when we come to certain fundamental core rights, and that was the theory behind RFRA, RLUIPA, RLUIPA, and until a few years ago, the First Amendment. I think that's where we can leave it at this point. RFRA is obviously, RLUIPA is obviously implicated, though I'd be interested to hear from especially Professor Laycock whether after Lukumi the developers might have their own constitutional claim, given the horrendous and vituperative record that has been so graciously made by so many people in support of the right of the sponsors of Park 51 to be there. So I will leave it at that. I want to thank again ACS and Melissa, and I look forward to this outstanding panel.
Thanks so much, David, for that very helpful background on the land use and institutionalized provisions of the Act. I'm sure our panelists will carry on with filling out a greater detail on both those provisions. And indeed, we want to turn to the panel portion of the event today, where we will have a variety of perspectives presented on RLUIPA. And in order to do that, I want to turn the program over to Bob Tuttle. Bob is the David R. and Sherry Kirchner Burrs Research Professor of Law and Religion at George Washington University Law School. In addition to his teaching responsibilities at GW Law School, I know many of you have read and appreciated Bob's writings on church-state law, as well as on various legal ethical matters, and he has written many books and articles and reports on those issues. He serves also as legal counsel to the Washington, D.C. Synod of the Evangelical Lutheran Church in America and a board member of Lutheran Services in America. So as you can see, Bob has got all the bases covered, and we're very fortunate that he was willing to join us today and moderate the panel, and we thank him for that, and thank you all the panelists for being with us as well. So I turn the program over to you, Bob. Thank you.
Melissa, thanks for the kind introduction, and thanks to ACS for bringing this great panel together. I'm delighted to be among the listeners in this group, and well, I don't know if I guess I'm happy not to be in the middle of it. So I'll be on the fringe. I'm going to briefly introduce all of the panelists. You have a fuller biography of each, so I'm going to be short with that. Each of them is going to give some brief opening remarks, and then I'm going to return to them and give them an opportunity to respond or extend, and then we're going to open it out to you all, and we'll talk about the audience portion of the event in a few minutes. Our first panelist today is going to be Douglas Laycock, who is the Armistead Dobie Professor of Law and the Horace Goldsmith Research Professor of Law at the University of Virginia School of Law. He's newly installed in those positions after moving from Texas just this summer. From Michigan, Texas before that, just this summer. It's no exaggeration to name Doug as the leading figure among scholars of law and religion. His influence is evident in every facet of the work in our academic discipline through a huge and rich body of scholarship that's now being collected in a 4-volume series. He's given his intellect and his energy to legislative efforts, and has been a committed advocate in litigation for the principles of his scholarship, especially the idea that religious liberty requires, in some instances, not governmental indifference to religion, but affirmative accommodation. Next in order will be Mark Stern, who is the Associate General Counsel of the American Jewish Committee. Mark was formerly General Counsel of the American Jewish Congress. He's been a highly influential leader in religious liberty issues as addressed by every branch of government through litigation, either as leading or advising counsel in high-profile constitutional disputes, as an architect of important religious liberty legislation, not least through his work with the RLUIPA Coalition, and leadership in the development of administrative agency guidelines for religious liberty in public institutions. Third, we'll have Marcy Hamilton, who is the Paul Verkyle Chair in Public Law at Cardozo Law School. Marcy is a star in the academic world of law and religion. Over the past 2 years, past 2 decades, I was going to say 2 years, past 2 decades, a very short period of time, Marcy has risen to prominence in our field through her scholarship, books and articles galore, legislative testimony, and her litigation, where she has tried to articulate and implement a vision of religious liberty that gives due protection to both religious communities on the one hand and those who are adversely affected by the conduct of religious communities. She's been a tireless advocate for those who have been harmed by sexual misconduct in religious organizations. I know because I've been on the opposite side of some of those cases. And as we'll see today, a defender of towns and cities in land use disputes with religious entities. For those who are familiar with City of Bernie versus Flores, which, as David said, was held unconstitutional, which held RLUIPA unconstitutional. We'll get the acronym straight. RFRA unconstitutional as applied to states and localities. You'll get some measure of the panel's prominence if you consider that the attorney for the City of Bernie, Professor Hamilton, and for Archbishop Flores, Professor Laycock, are on our panel today. Next, Roman Storzer, who is a partner in Storzer & Green, spent a decade as Director of Litigation for the Beckett Fund, and since that time, Roman has been, and during that time, he's been among the most active and successful counsel for religious organizations involved in land use disputes. He's been out in private practice outside of Beckett now for the past 6 years, first as a solo practitioner and now with Storzer & Green. And if you look at the list of cases that he has been either lead or participating counsel in, you can really write the history of RLUIPA litigation over the last decade. Most importantly, I should say, we're proud to count him as a graduate of GW Law School. And finally, Elizabeth Merritt, who's Deputy General Counsel for the National Trust for Historic Preservation. In the world of preservation law, there is just no name that is better respected than Betsy's. For the past 26 years, she has led the legal advocacy work of the National Trust in litigation, in administrative negotiation, which is, I think, where most of her work has probably taken place, and then certainly in her legislative influence to protect the nation's historic places, including, of course, historically significant places of religious worship. And so we're delighted to have Betsy, we're delighted to have this entire panel, and we will turn it over first to Doug.
Thank you, Bob. I hesitate to quibble with David Lockman, but I think RLUIPA emerged from RLUIPA not so much as a compromise, but as the two pieces that could be passed. And it's kind of an odd couple. But 9 hearings over 3 years on RLUIPA had devoted a lot of attention to land use, and it developed a broad bipartisan support for the view that there was a problem with land use regulation of churches and that legislation was needed. Grassroots lobbying, especially by prison fellowship, got the prisoners included, to the surprise of probably nearly everyone in Congress. What had been threatened to kill the bill if you put them in, now threatened to kill the bill if you left them out. So those are the two pieces, and the litigation and enforcement has been rather separate. The land use piece is mostly under the enforcement clause of the 14th Amendment because land use regulation is so individualized. Commerce Clause available as a background backstop. The prison litigation is mostly the legislation is pursuant to the spending clause because nearly all prisons get federal money. Commerce Clause is also available there as a backdrop, but really hasn't been used. There's a recent student note in the UCLA Law Review that says the land use piece is a failure. Churches aren't winning any cases. In the cases they do win, they would have won under the Free Exercise Clause anyway. The most aggressive critics of the law say that the land use piece has empowered churches to terrorize neighborhoods, and they're taking full advantage, and they're imposing on their neighbors and doing terrible harm. The truth, not surprisingly, is somewhere in between. The act has not achieved the greatest hopes of its supporters, and it has not caused the worst fears of its opponents. Some judges have enforced it sympathetically. Some judges have resisted and tried to throw sand in the gears, and all of that was entirely predictable. That's how legislation works. The opponents confidently said the law was unconstitutional. So far, the Supreme Court has unanimously upheld the prison piece as against an Establishment Clause attack, and the courts of appeals have been upholding both pieces as against claims that they exceeded Congress's powers. There's relatively little disagreement about that in the lower courts, a couple of district court decisions that went the other way. The Supreme Court has not found it necessary to consider that issue. There's no circuit split, and it does not appear to have been sufficiently interested in the question to reach out for it. The successful claims under RLUIPA would often have been successful under the Free Exercise Clause anyway. It is legislation to enforce the Free Exercise Clause. But these claims were not being taken seriously before RLUIPA, and they are being taken more seriously now. And my view is really that was RLUIPA's great achievement. It creates statutory language, and the litigation now proceeds under the statute and not under the Constitution, and that matters. But what may matter even more is the hearing record, the congressional judgment that there was a problem here that required legislation, the equal terms provision, which opens up the litigation, suggests to courts you got to look not just at the property before you, but at other properties around town. All those things have led judges to take these cases more seriously than they did before RLUIPA was enacted, and to look at the pattern, not just can the church locate on this property, but is there some other place it could locate if it can't locate here? How have other places of public assembly been treated? How have other churches been treated? None of that was going on before. Every religious community needs a place, a physical place to assemble for worship. So building a church or locating a church is a core First Amendment right, but it had been viewed as a property right. What you're going to do there later might be the free exercise of religion, but building a church is just property, and we can regulate that the way we regulate everything else. And to a significant extent, RLUIPA has changed that. The statute says using real property for the exercise of religion is itself the exercise of religion. There's a big circuit split on what it means to be a substantial burden. I think the underlying factual split is not as deep or as mixed up as the split in verbal formulations. But there were key members of the coalition that passed RLUIPA that refused to allow any statutory definition of burden, and so not surprisingly now we are arguing over what burden means. And in the land use context, that is a particular kind of question. It's about, how much inconvenience, how much travel distance, how much extra expense becomes so burdensome that it's a substantial burden on the exercise of religion. In the case of Orthodox Jews, how much extra walking, and do the elderly count, or do we measure this by healthy young adults? There's resistance to the extra terms provision. More surprising, I think Mark Stern is going to talk about that a bit. Congress enacted that as an absolute right. They thought there was just no justification for preferring places of secular public assembly over places of religious public assembly. A lot of judges can't believe they really meant for it to be an absolute right, and so they're inferring justifications, and some of them are pretty squishy. So in some circuits, that provision is serving its purpose, and in some circuits, it is not. A lot of the cases that churches are losing probably shouldn't have been filed in the first place. No surprise, courts have held that going through the land use process is not itself a substantial burden. It may be frustrating when they've obviously made up their minds and the whole process is futile, but you got to go through it. Then you get a chance to go to court, and there just did not appear to have been much litigation about. One thing we were worried about, that people would say the regulatory process is now res judicata. You had your chance. You don't get to go to federal court. Statute's clear on that. That's been working. Churches have tried to file eminent domain cases. We got rolled on that. Land use means zoning and landmarking, period, nothing else. That was put in at the insistence of environmental lawyers who were afraid environmental law might be defined as land use regulation. It came up at the very end. There wasn't a chance to get it drafted right, and so some cities have been able to just condemn the property and give it to somebody else, as they're entitled to do under Kelo, and now it's not a zoning decision, it's an eminent domain decision, and RLUIPA has not been able to do anything about that. We have some overreaching claims. On one side, we still have overreaching regulation. On the other side, we have prison authorities doing wholly arbitrary things. We have towns that say 40 acres is not enough for a church. If the church had 100 acres, I can tell you that would not have been enough either. And of course, at this 10th anniversary, we have the dramatic conflict over the Islamic Cultural Center in Lower Manhattan. Most of the opposition to churches isn't that open, obvious, and unsophisticated. There's a lot of it out there. A lot of churches are able to locate with no problem, but a lot of churches are not, and I think RLUIPA has made a real difference, level the playing field a bit in those kinds of conflicts.
Just a word about something David talked about. I was with Justice Scalia a few years ago in Israel, and somebody asked him from the diplomatic community what his most important decision was. And without batting an eyelash, he said, Smith. He said, and then they passed this silly law to overturn it, and we threw that out. And I'm standing there behind him saying, but he was quite serious about it. It was a question out of the blue. So apparently he thinks highly of his decision in Smith. Doug told you the history of how prisoner protections got into the Act. Frankly, we were uncertain at the time whether we could compile a record, given the Supreme Court's new, I think, made up of whole cloth, congruent and proportionate test. We hadn't made the effort in the hearings. They're very discrete cases. That it's very hard to make a record, certainly not without massive resources, which we didn't have. When the case got to the Supreme Court in Wilkerson, the case was over when Justice Stevens turned to the attorney for Ohio and said to him, well, you accommodate Christians, right? So all this act does is say that everybody else gets the same treatment, right? And, you know, at that point, everybody in the courtroom understood that Ohio had lost. What's interesting is the statute that most of us conceived of in terms of liberty gets the vote of Justice Stevens, who was the most suspicious on the court about religious liberty, on an equality basis, a point I'll come back to later. I think there's a larger point to be made about RLUIPA in prisons, which is that in general run of prisoner rights cases, the Supreme Court has drummed into our heads that if you recognize inmate claims, inmate constitutional claims or statutory claims, that especially if you have robust judicial review of those claims, that's going to undermine the prison authorities' control, and all sorts of horribles are paraded. Anybody who's ever been a law clerk knows that state attorney general papers just sort of recite that stuff. In my day, which is so long ago, that was even before word processing, they had canned briefs that said all that. Sometimes it was amusing. They forgot to change the facts in the case. But it was sort of canned, you know, we'll have riots and so on. And to the best of my knowledge, there's not been a single prison riot, security breach, or escape that can be attributed to RLUIPA. And one lesson that perhaps we ought to derive from that is that the fears of robust judicial review in the prison or any other institutional context may be overstated. Judges really aren't all that wild and crazy, and they do act responsibly when you make a record. And so perhaps one lesson is that Congress ought to be less bowed by those fears, and at least when other rights come up in institutional context and the response is a parade of horribles or potential horribles and loss of control, that RLUIPA shows that that's not so, that you can have robust review and not lose control. Another objection to RLUIPA is that it formally singles out one group of right bearers for special benefits, and it's therefore an establishment of religion. I'm simplifying the argument, but that's what I think it boils down to. And in formal terms, that's of course true. The effect, however, is exactly the opposite. I remember there was one case out of Tennessee. It was a planned community, and they zoned, this came up in one of the hearings, and they zoned some land for churches in this planned community. 4 lots, in fact. And on every one of those lots, there was an existing church. And so what you had was precisely an establishment of religion in the form of an accommodation of religion. The churches that were there already got to stay. Nobody else could move in. The status quo was frozen in time unless somebody bought out an existing church. And you hear all the time in these cases, municipal officials will say, we have enough churches in town. You don't need that one. You can go to the one down the corner, as if churches were somehow ideologically fungible. It really doesn't matter what goes on inside of them. Now, there is a point of view in theology and in sociology that that's the case. But that's not our constitutional law. A further concern that's been expressed by some first-rate civil liberties lawyers, I heard it's from Steve Shapiro of the ACLU, was that the use of compelling interest in the context of zoning might lead to an erosion of the importance and magnitude of compelling interest in general. And it's a fair point. Especially municipalities insist that a parking space in front of one's home is a compelling interest. There is a fear that that sort of argument will wear down the importance of compelling interest. I wish there had been some other formula of words we could have used that might have taken that objection into account. Simply as a matter of you have to balance what's ideal with terms that everybody has a fair idea of what you're talking about, and you're not buying 10 or 15 years of litigation until you come up with a meaning for a new term. And we settled on compelling interest, knowing that that objection has been made. Doug talked quickly about the equal terms provision. The Third and Seventh Circuits have read the statute quite narrowly. It has to be equal in terms of the purposes of the restriction. And so if you carve out a zone in town, which is an entertainment zone or a tax-generating zone, and you exclude churches, that's not a violation of equal terms, because everybody who's not an alcohol-serving, entertainment-providing provider is kept out. The 11th and I think the 10th, I haven't had a chance to read their newest decision, seem to have rejected that reading. The confusion here, or the disagreement, probably stems, as Doug said, from the fact that we couldn't conceive of any legitimate reason for teaching secular and religious institutions differently, and so we left out compelling interest as a defense. Some courts have read it in and therefore read the statute more strictly. Other courts said, well, Congress left it out, but that leads to absurd results, and it's results they don't like, and therefore we're going to create another defense rule. And finally, I want to talk about a sociological point, not a legal point. RLUIPA and RFRA, well, RFRA in particular, as David mentioned earlier, led to a wall-to-wall coalition of religious groups, the likes of which in 30-some-odd years of practice, Doug, been at it almost as long as I have, or maybe longer, I've never seen before. And one of the things that came out of that was a sort of era of religious good feelings. Now, we still fought about abortion, and we still fought about aid to parochial schools, but things were done on a very friendly basis. And as a result, I think of the fact that we all got to know each other and learn that, wasn't the demon lurking behind. There's some wonderful stories for those of us who are veterans of the years of Forrest Montgomery of the National Association of Evangelicals surprising civil libertarians with some of his views. And, of course, to say nothing of surprising evangelicals with some of his views. But out of that, I think, came the religion in the public schools, a couple of things that Charles Hines has done after that, a religion in the federal workplace, more or less grew out of the same coalition. So did the International Religious Liberty Act, came out of that same coalition in the same period. So there was an era of good feeling. It lasted for about a decade. After Bernie, that coalition sort of became undone and has not been put together. Part of that, I think, is the general polarization of American politics, law, and life. But part of that was with two particular concerns that arose out of the effort to use the spending clause to secure religious liberty. The first, and Doug mentioned this, was on the very far right of the coalition. There were efforts to deny that the spending clause really gave Congress the power to do anything, to the point where one head of one organization actually testified to Congress that internal improvements of the 1840s were unconstitutional, to which Charles Kennedy famously responded, well, you're 150 years too late to arrive at this committee. But the other is the more important one, and it's the lingering one, and that is the split between those who see religious liberty as a individual liberty right in its own right, important in its own right, and the chips will fall where they may, and those who see religious liberty as primarily an equality right. And that, of course, manifested itself in the dispute whether religious liberty legislation ought to include civil rights claims, that is, claims that civil rights laws impinged on religious liberty, or whether they ought to be categorically excluded. The best we could do as a compromise on that was simply not to talk about it at all. That cleavage continues to this day on a series of legislation and court litigation, which are all obvious to those who follow the field. I just want to conclude that in some cases, RLUIPA nicely manages to split the difference. And the mosque downtown, of course, those of us from New York, downtown means downtown New York. For those of you not privileged to be New Yorkers, it's too bad, it's downtown. And there, equality and liberty coincide, and so the coalition will, I suspect, come together should anybody be foolish enough to try litigation to stop the mosque. But the broader split exists and will continue.
Thanks, Mark. Marcy, can you make sure you hit the button?
Can I use the podium?
That'd be great.
I'm so short, I feel like I'm under the table here. Hi, everyone. After hearing that, I almost feel like I should change my position and say RLUIPA is a great statute, but it's not. Let me just make a few quick comments because this happens all the time and I think it deserves correction. Justice Scalia did not decide Smith by himself. The Supreme Court decided Smith. It wasn't even a plurality. And it's always a political move to try to pin Smith on Scalia rather than to talk about how a majority of the Supreme Court held that religious entities do not have a right to violate the law that is neutral and generally applicable. And we really are not talking about whether or not religious groups will get buildings. We're talking about whether or not they'll get the location they choose. Almost all of these cases are zoning cases involving location, 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 and religious groups have used RLUIPA repeatedly in the land use context as an argument for a special privilege to avoid whatever master plan the local government has in place, whatever preferences the local government has put in place. I have yet to see a single claimant on the side of a religious entity say that there's any compelling interest in anything. They don't make the argument. We've had cases saying that the carrying of blood-borne diseases and concern about that is not a compelling interest. We've had cases saying that fire safety, really not a compelling interest. So basically what we're dealing with here is political opportunity following Smith, and you can see the political element to it when you hear that it's Scalia's decision. It's that conservative Republican's decision, not the Supreme Court. So let's talk about some of the facts that are actually on the ground instead of the theory that was behind RLUIPA and unfortunately put it in place in the first place. RLUIPA creates a dramatic change in the law. Strict scrutiny was not applied in land use cases, as Doug implied. And Cambodian Buddhist, it was a case decided in the Connecticut Supreme Court. And I give you the state cases as education. Everyone should read the state cases because state courts were handling land use. And the Supreme Court of Connecticut said, we didn't apply strict scrutiny in these cases. They had heard hundreds of land use cases. The federal courts have not done land use in any kind of nitty-gritty way except for the Fair Housing Act until RLUIPA. All of a sudden, they now get land use cases. I will never forget arguing in the Second Circuit in which I had a federal judge say to me, now, what is a conditional use permit? I said, and I explained it to him, and he said, oh my God, we live in communist Russia. Every locality has either special or conditional use permits, which are used to squeeze in uses that might not be consistent with the designated use, but that should be there for the interest of, in the interest of the public. Luckily, that court understood that the one line that must be drawn is religious groups must go through the process. And that was the Murphy case, and the Second Circuit rightly held that
RLUIPA did not give this blanket privilege to avoid land use process. They must go through it. Unfortunately, Doug is apparently unaware of the many cases in which religious claimants have defied the land use process altogether. That is a common claim. There are pending cases right now in Roosevelt and in New Jersey and Pomona, New York, among others, where the religious claimant went to federal court before filing a single application. Imagine writing a response to a complaint in which the response has to say things like, the alleged plan, because no one's ever seen a plan before. That is where religious groups are pushing the envelope repeatedly. They now view RLUIPA as an opportunity to get around the law altogether, not as some way to level the playing field. This law has been terribly unfair to homeowners. I hear from a homeowner a day, all across the country. Not one so far has been a religious bigot. In fact, they've all been religious. And every one of them says to me, I'm religious. I'm not opposed to religion. I'm in favor of the wide variety of religious groups that are in our town, but I bought my home in a residential neighborhood, and I never expected a church to buy the 5 lots next to me and put in a parking lot for 200 people. I never expected to have a yeshiva in a neighborhood of 1/2 acre lots and then have 3 of the houses turned into dormitories, all against the code, all using RLUIPA to claim they have a right to do it. So the notion that we have somehow righted a wrong is simply misleading. It's not true. There have been cases of claims involving discrimination. There's no question about it, and the First Amendment is more than adequate to the task. The primary area, 1 minute, okay, well, I don't have any more criticisms. The primary area that needs to be reexamined by Congress and needs to be reexamined immediately is fees, attorney's fees. The way attorney's fees operate right now is that under Section 1988, generally, which is the model that's being used and is the way it's operating, if you are a religious entity and you bring a case, you can threaten the local government with having to pay all of your attorney's fees. That's the standard opening gambit by every religious group. But if you're the government and a religious group drags you through court for 5, 10 years, which is what land use cases tend to take, you only get fees as the government if the case was brought frivolously. Now, just in case you don't know who's paying for RLUIPA lawsuits, when attorney's fees are being paid by local government, it's you, right? Taxpayers are picking up the cost of RLUIPA. At the same time, they're finding that the residential neighborhoods are not important. Nothing's ever as important as a religious project, regardless of the intensity of use, as compared to a residential homeowner. Plus, residential homeowners also have the privilege of having the lawyers and the litigants in these cases refer to them as bigots, discriminatory, small-minded, when their only point is, I bought a house in a neighborhood. I really didn't want a homeless shelter next door. That is not an irrational perspective, and it's one that was wholly absent during the hearings on RLUIPA. Nobody involved in RLUIPA thought of homeowners, and until they are thought of again, we will have the situation where we have now. One neighborhood in the country has been able to fight its way against RLUIPA's imposition on its neighborhood. They were all Hollywood producers. They're the only ones who can afford it. So right now, the losers are the residential homeowners. Thanks.
All right. My view is also one from the trenches. I've had the pleasure of litigating against Marcy on a number of cases. And my experience, of course, comes from a different perspective and itself is quite different. First thing I'd like to say is that my own experience litigating scores and scores of these cases is that it proves what Congress heard when it was considering this legislation, and that is that it is minority religions that are the ones that get the brunt of the hostile and targeted land use activities and legislation. My clients are very predominantly what one would call minority religions: Buddhists, Muslims, Orthodox Jews, non-traditional Christian sects. And it may not be a statistically significant sample, but it seems to me in my practice that they're the ones that somehow get the short end of the stick when these neutral and generally applicable laws get applied to them. RLUIPA has had a good effect so far in the last 10 years. It has brought the issue to the attention of local land use officials where it did not exist before. It has the threat of a Department of Justice investigation obviously is a great factor that comes into the minds of these officials, and that has been extremely helpful. What local governments, though, have done in response to RLUIPA is they've gotten smart. They have stopped, in most cases, saying we don't want this group or that group, outwardly making hostile statements, saying Muslims don't belong in our neighborhood. Of course, that still does exist occasionally. We've seen it in Lower Manhattan. I've had the dubious pleasure of being able to litigate in cases where such hostility was rampant and was adopted not only by the local residents but by their officials themselves. But generally speaking, local governments have started to realize that they're going to get in trouble if they keep doing that. And what they do is they start looking at their staffers, they start looking at their planners and saying, if there's a use that we don't want, and by we don't want, 9 times out of 10 it means a local community group doesn't want development near them. Even if that development is religious and is permitted by law, the zoning code allows it, they're in a zoning district that permits it, let's see what we can do to keep them out. And so they pass new laws, new legislation under the guise of environmental protection, protecting water quality, protecting traffic, what have you, that they can then hopefully later try to defend on the basis of, well, we didn't want this mosque on this perfect location for a mosque in our city. We just meant to reduce the number of cars driving down this road. Even locally, in the last couple of years, I've represented a number of institutions where exactly this has happened. Although since Marcy raised the case of Pomona, that is a perfect example. An Orthodox Jewish group bought 100-odd acres to place a rabbinical college in this location. The town or the village of Pomona decided immediately thereafter that it had to suddenly regulate educational institutions and started passing new ordinances making this particular use, which was legal to begin with, now illegal. A law saying, for example, that dormitories could not have kitchen facilities or dining facilities. Well, why did that matter? The reason it mattered is because the students that would be studying at this religious college tended to marry young, have families and such, and needed such facilities in order to be able to study to become rabbis. So they were effectively zoned out. More locally here, we have an example of a Muslim group that purchased 225 acres of land in the town of Walkersville, just outside Frederick, up 270, for a mosque and for an annual religious gathering. The uproar was absolutely deafening. I attended the town meetings. They had to set up closed-circuit TV systems for all of the people that couldn't fit into town hall that wanted to keep these people out. the town actually passed a law saying that religious organizations which were previously allowed in this zoning district now were not allowed. After the Muslim group went away, they repealed that law. In the Reaching Hearts case against Prince George's County, another church bought property to place a religious institution there. The county then decided to pass a new law saying that lot coverage has to go down from 50% coverage to 10% coverage for certain non-residential uses in residential zones that were within 2,500 feet of a drinking water reservoir, which effectively prevented the church from building there. A jury ruled that that county violated RLUIPA, and the Fourth Circuit then upheld it. That kind of gerrymandering law is quite common. My favorite example is another one of my cases against Anne Arundel County, where the Riverdale Baptist Church bought a large piece of property to build a religious school on a parcel that was zoned for such a use. The use was permitted by right. The county then went through a process of deciding exactly how they could keep the use out of it. There was great local hostility. They spoke to their councilman. Councilman decided to pass a number of laws, first of which was to say you can't locate private schools on anything less than an arterial road classification, even though most of the schools that existed in that county exist on lower classified roads. Then the county decided, well, we're going to pass a new scenic and historic roads law, and we're going to ban private schools from locating on such roads. Oh, and by the way, both of the roads that your property is adjacent to, we're going to call scenic and historic roads now. So it's these kinds of cases, cases involving what critics would probably call neutral and generally applicable laws. After all, we're just protecting scenic and historic roads. But they're targeted at these uses. They're meant to keep them out. And again, we have to be careful of these more subtle forms of discrimination, subtle forms of targeting that's happening to churches 10 years after RLUIPA was passed.
Thanks, Ron.
Is this on? Yes. Greetings. I'm honored to be among this illustrious panel, and historic preservation is something of a footnote in the annals of these religious liberty statutes, but we have on occasion played a very interesting role in the development of the law. I think it's fair to say that I am one of the individuals responsible for the insertion of the word substantial in the language of RFRA. As I was hearing reference to this before, since we're reminiscing at this event, the way it occurred was that the National Trust for Historic Preservation found out about RFRA at the very last minute and began to realize what we were concerned would be the draconian implications of the legislation for the protection of historic religious properties. And we went to the Hill, and we went to Jeff Blattner on Senator Kennedy's staff, and we said, Jeff, do you realize what you're proposing here? A law that would provide a cause of action for any burden, not just a substantial burden, any burden on religious exercise? Think about what you're setting in motion there. And we spent some time really trying to persuade Senator Kennedy and Senator Hatch to change the language. And of course we were told, you know, there's no way we can change it. This has already got, you know, everybody signed on to it. It had already passed the House. There's absolutely no way we can change it. And so it was a real cliffhanger for us. And on the day when the legislation, when RFRA was passed on the Senate floor, I happened to be homesick from work, which is something that happens about once every 20 years. And I was watching on C-SPAN the deliberations and was relieved at the last minute when the word was inserted through a floor amendment. But the National Trust actually played a really specific role in getting that language, in shaping that language. And then historic preservation also had a role when the Supreme Court selected the Birney case as the test case to evaluate the constitutionality of RFRA, which was such an ironic choice because historic preservation was, you know, only a very small segment of the cases that were being litigated under RFRA. And so it was ironic that the court chose Bernie as the case in which to evaluate the statute's constitutionality, but in many ways, Bernie was a very typical case of the kind that arise with respect to historic preservation, because it was a case where when the local government said no to the church's proposal to demolish the vast majority of its historic church building and build a massive addition, the church was unwilling to follow the recommendation of the local Historic Preservation Commission to modify the design in a way that would preserve a greater portion of the historic building. And so the local government was saying, we're not preventing you from expanding, but we think you should do it in a way that's more compatible with the historic character of this church, which is our town icon. And all that was set aside while the litigation went to the Supreme Court. And not surprising in our view, as soon as the Supreme Court litigation was over, the parties were able to resolve their differences in Bernie, and the expansion of the church did go forward in a way that was much more compatible with the historic character of the property. So one thing about historic preservation laws at the local level is that historic preservation laws rarely result in an outcome where a house of worship is either excluded from a certain location. The historic preservation laws wouldn't say you can't have a house of worship in a historic district, and rarely do they involve an all or nothing outcome. Usually there are issues of design or size or where the parking goes, or vinyl siding, or that sort of thing, design issues. And virtually every local historic preservation law also has an economic hardship provision. And in fact, that's the provision that was invoked with respect to the third church here in DC, the Christian Science Church on 16th Street, which wants to demolish its church building. And in fact, in DC, just recently, the city government approved the church's application for an economic hardship exemption to the normal rule that demolition of a historic property is not permissible. Now, that ruling is being challenged, even though the courts have construed RLUIPA appropriately in the context of historic preservation. The real story is what's going on outside the courthouse door, in our view. As others have alluded, churches are threatening litigation with the consequence of attorney's fees, pressuring local governments to capitulate to granting their applications, their land use applications, whatever they may be. And it has produced a tremendous chilling effect on local governments' regulations of historic religious properties. And it's very difficult to measure that. We all hear anecdotal reports, and because of the fact that you can't research these things like reported cases, it's very difficult to actually quantify how many times how frequently are local governments backing away from these kinds of demands by historic religious properties, and how frequently are they capitulating. That's a difficult thing to measure. We did persuade Congress to include within RLUIPA special language in the legislative history that addresses some of the concerns about the land use portion of the statute in general, and, for instance, confirming that the definition of substantial burden should be consistent with the definition adopted by Supreme Court jurisprudence, and clarifying in what we called the St. Bartholomew's exemption that it's not religious exercise if you've got a commercial building which funds religious activities, and a burden on that commercial building doesn't necessarily translate to a burden on religious exercise. So we were able to get a few of those issues clarified, and going forward, I think the real story is how does this play out in the behind-the-scenes dealings between religious property owners and local governments as far as making those off-the-record decisions about approving requests for deviations from what the law would otherwise require. Thanks.
Thank you all very much. I think the best way for us to proceed is for each of you all to have an opportunity for a brief extension or response of what you said before. So we'll start in that order with Doug. And then once we've done that, we'll open it out for questions.
Well, I think the action has been in zoning has been much less about land. Thank you. The action has been in zoning. Often the question in these cases is there any place else they can locate? And very often the answer is either absolutely no or no at any cost that they can afford. And we see in the cases the same patterns that were reported in the legislative history, that all the places zoned for churches are already occupied by churches, so no new church can locate. Professor Hamilton likes to talk about the residential cases, and there are still some of those, but there are more commercial cases. We have cities who say you can't put your church in a residential zone because it causes too much traffic, and you can't put it in a commercial zone because it causes not enough traffic. It doesn't bring people through to use the rest of the commercial services. We have a body of regulation that is highly individualized, has standards that are highly amorphous. We have, not just with churches, but with lots of development, a NIMBY opposition, people who say not in my backyard, but everywhere else is going to be in someone else's backyard. And so we had a problem that simply gave no weight to the fact that there was a First Amendment activity going on here. If we change the attorney's fees provision, we may as well repeal the statute. Many of these are small churches trying to get started. There was testimony in Congress. I don't practice in this area. I can't verify it myself, but it certainly made sense. The zoning board denies the permit. The burden of litigation is on the church. They've got to keep themselves together for 5 years while the case drags on, and they got to pay the attorney's fees. It just didn't happen, right? That boards in a high percentage of cases could deny permits, fairly confident that the judicial appellate process wouldn't happen. The attorney's fees makes it possible to actually litigate these cases. It may be hard on an occasional town acting in good faith, but it's essential to enforcement, and it's pretty clear, as Roman's examples indicate, a lot of these towns are not acting in good faith.
I don't think there's a piece of legislation that Congress has passed in my lifetime or several lifetimes before it that you can't show that people have abused. And it's interesting that Marcy keeps talking about the claims that are made. Well, sure, lots of claims are made that are frivolous. That's true of defendants as well as it is of plaintiffs. And they shouldn't be brought, and people shouldn't be trying to run around the zoning process procedurally. They're tempted to do it when every member of the town council has announced in advance that this building's not going to be built. There's a sort of futility about going through a 5-year process when you know that the result is already foreordained. But I would urge you to evaluate the statute, not necessarily in what the claims are made, but in what wins in court, because that's what sets the standard for everything else. It is true that a lot of what goes on in RLUIPA goes on behind the scenes in negotiating in lawyers' offices and like, and it's very difficult to get a sense of what's going on. But nevertheless, I urge you not to look at claims, but at what wins, and because that's what sets the standard. The fees provision is no different than every other civil rights statute. Those of us who remember the major civil service Title VII cases of the 80s, when adverse impact was in standard and in vogue and enforced vigorously by the courts, there was case after case where cities had legitimate defenses to a Title VII case and simply caved in order to avoid attorney's fees. That's a necessary downside of all attorneys fee shifting positions. As Doug has explained quite eloquently, it's essential. I think what I find most troubling about Professor Hamilton's presentation is the assumption that liberty is cost-free. And as soon as it imposes a cost, then it's not a good thing. Before we had our RLUIPA, towns used to object to churches and synagogues and hospitals, for that matter, on the grounds they're not rateable. They don't produce tax income. Go someplace else. Sure, if you buy a house and a church or a shopping center or something moves next door, there's a cost to that. But there's a benefit to the larger society. And the impacts are always local. The benefits are often more diffuse and spread out. And we as a society have decided that we don't want a stultified religious economy. We want an economy with low costs of entry so that we can, you have to compete in the marketplace and win. That's a larger social issue. When you get to this town or this block or that block, all you see are the costs. If you look in a more global perspective, which is what I think Congress did in passing our RLUIPA, there's an interest in making sure that those local costs don't overwhelm the benefit. And finally, an anecdote. I represented a small synagogue in Wayne, New Jersey. Wayne is a town that had rapidly suburbanized, and previously had been pig farms mostly, and they hadn't even updated the zoning ordinance. They had detailed provisions for pig farms and none for houses of worship, which is sort of funny. Anyway, I represent the synagogue, and one member of the board goes on and on about how if we don't keep out small houses of worship, we'll look like Patterson, which is an adjoining urban, downtrodden town, which is many poor communities, has lots of storefront churches. And I said I didn't think bigotry, it was very obvious what he was signaling, was that black and Hispanic people were not welcome in Wayne. I, wearing my yarmulke, said that's sort of bigotry represented by will look like Patterson doesn't belong in a governmental process. At which point the member of the council had said it, got very angry and started demonstrating to me that he wasn't an anti-Semite. To which I responded, but I didn't call you an anti-Semite, I called you a racist. That goes on, we all know it goes on. How much of it we can debate, but it goes on and it ought not to be blinked. If I may, just for 1 second, Doug managed successfully to argue Church of the RLUIPA after I told him he had not a chance in the world of getting a majority. He won unanimously as to result. He did not get if I remember correctly, there's not even a majority opinion for exactly what the test is. There's a good deal of confusion about whether it's intent, motive, whether you look at it objectively or not. So if people think that you can come in and show that lots of people said bigoted things and therefore you win directly under the First Amendment, that's not so clear. There are 2 votes for that proposition in City of Hialeah. Justice Scalia says that's all irrelevant. So some of the very worst cases of bigotry can go entirely untouched under the First Amendment, although I think most district judges would find some way to throw it out anyway. But in legal theory, those cases are not easily winnable. And our RLUIPA gets you over that with a much harder standard.
Just a couple quick points. One, I would like to thank both Doug and Mark for no longer creating mythology that our RLUIPA was passed unanimously. That was something they played out for a while. It, of course, was passed by unanimous consent at the time that Congress was going away for the summer. The vast majority of members had no idea it was being passed. There were 2 members in each house. And the opposition was building, which is why it had to pass at the time that it did. The opposition was coming from the National League of Cities, the Attorneys General, and many children's groups who were unhappy about various aspects. So the notion that we have America speaking for religious liberty is baloney. It was basically interest groups on behalf of Chuck Colson's Prison Fellowship Ministry and, of course, the evangelical Christians who fought hard in order to avoid land use costs. So let's just get the history correct, all right? That's all I ask. All I ask in any debate about religion is facts. And the facts are sometimes very hard to find. And so what I'd like to close with is by saying to David, when our RLUIPA was passed, a number of groups were promised that 3 years after it was in place, that there would be hearings on it to see how it actually impacted. National League of Cities was told that, as were others. Given the debate between Doug and I, who are involved in these cases heavily, over whether these are really about commercial districts or residential entities, I would very much appreciate and encourage your boss, as well as the judiciary committees, to have hearings on the facts of the application of RLUIPA, both in the land use and the prison context, but primarily in the land use context, where so much of this goes on behind closed doors. And I would especially encourage Department of Justice Eric Treen to come and testify regarding the communications between private attorneys like Roman Storzer and the DOJ, asking the DOJ to bring in their heavy artillery in cases where it's going slowly. I've now seen it happen in 5 cases at least. I think it's highly inappropriate, and I think that if we could get some facts about RLUIPA, there might be a better debate. Right now, the facts are hard to substantiate because we have two sides so far apart. So I think that hearings in Congress would be a great idea and would benefit everybody, including the Americans who are suffering under it or benefiting from
it. To tie in a few of the speakers' comments, another data point. One of the heavy artillery, I guess, was an amicus brief that the Department of Justice filed against the Township of Wayne, New Jersey, in a case I represent. I was involved in. The Albanian Associated Fund was a mosque that had previously existed in Patterson, and they wanted to move to Wayne. And for the first time in its history, the Township of Wayne decided that it needed to take by eminent domain the piece of property that the mosque bought to locate its place of worship in. Of course, I suppose there might be equal opportunity offenders in that jurisdiction. It's clear that tying back to one of Doug's comments, that was actually a case where the court held that RLUIPA applied to the exercise of eminent domain, one of 2 that we've had. There's a way of reading RLUIPA which says that if there's an implementation of a land use regulation, and of course the Township of Wayne's ostensible justification in that case was to protect its open space, its comprehensive plan, etc. And the way it was going to do that was by taking this property owned by the Muslim group. Switching gears for a second to the historic preservation issue, I'm actually quite surprised that 10 years later we have so few decisions, in fact, so few cases involving historic preservation. I thought that there would be a lot more. Religious buildings, of course, are landmarked at a much greater rate than probably, well, I'm not sure if it's any kind of building, but certainly more so than most other buildings. I represent the Third Church of Christ Scientist in D.C., and they're, I think it's fair to say, a horrendous bunker-looking structure on the corner of 16th and I Street, which was landmarked. And the mayor's agent in that case, in deciding that deciding to grant the demolition permit of the church after much discussion about the impact on the church's religious exercise, interpreted the appropriate DC regulations in such a way that the preservationists now are challenging that in court. What the preservationists argue is that the exceptions to the landmarking scheme require an actual taking of the property, and that's what's meant by an economic hardship. And that standard, a taking, is certainly, I would argue, and I think most people in this room would argue, is much higher than whatever a substantial burden on religious exercise means. The takings jurisprudence obviously is a well-defined body of jurisprudence. We know what it means. We don't quite know exactly what a substantial burden on religious exercise means if you look at all of the decisions that have come out in the last 10 years, but certainly there's some space between those 2 points. We, of course, filed suit in federal court after after the landmarking of the building, saying that that landmarking itself has substantially burdened the church's religious exercise. We recently filed suit in Indianapolis against that authority's landmarking of a 1920s building that the church wants to take down, move to a more appropriate location. In both cases, the religious organizations, the buildings are literally crumbling. They cannot afford to maintain them. Their financial projections are that the churches will become insolvent in a few years if they have to keep spending most of their revenues on maintaining the buildings themselves. But Indianapolis decided, well, we're going to pass a new amendment to their comprehensive plan, which was the St. John's United Church of Christ plan, which was the landmarking of the building. And again, this type of regulation has been characterized as a neutral law of general applicability. In reality, though, the plan itself creates a historic district which is coterminous with the boundaries of this parcel of land and certainly anything but.
Is this still on? I too am surprised that there have been so few decisions on historic preservation under RLUIPA, but I would like to take issue with a couple of the statements that Roman made. In my experience, in my 26 years of working at the National Trust, religious buildings are not landmarked at a greater rate than other buildings. And on the contrary, and particularly in the last 2 decades, local governments are extremely nervous about landmark designation for religious properties. And if there is opposition by the owners of the house of worship, then local governments are very reluctant to go forward. And so, in my view, religious buildings are less frequently landmarked than other historic properties. And I also wanted to point out that under the economic hardship provision, it is actually extremely typical for an economic hardship provision in a local landmarks law to be equated with a taking standard. And that was the law that was at issue in the St. Bartholomew's case in New York City. And there the Second Circuit, using constitutional standard because it was pre-RFRA and pre-RLUIPA, said that the denial of the demolition permit in that case was neither a substantial burden on the church's free exercise of religion nor a taking, because the church had raised both claims. But just to clarify, it is very typical that economic hardship provisions in local landmark ordinances are based on the taking standard. I guess I'd also like to say that one of our primary goals is to see that historic religious properties are treated equally with other properties. And so we feel strongly that historic religious property should not be above the law or exempt from the laws that apply to other properties, but also that they should not be discriminated against. And the vast majority, of course, of the legislative history that led to RFRA and RLUIPA really is about the discrimination problem, and not only in discrimination in land use, but also discrimination in availability of funding. And so our view is that these properties should be eligible for equal treatment with other properties, but at the same time should be subject to equal responsibilities for complying with the legal standards that apply across the board to all property owners.
Thanks, Betsy. We're going to have a microphone at the back for questions. If you don't mind, if you have a question, if you don't mind going back there, because they're recording this, and that's where the microphone is to record things. Would you please tell us who you are and where you are from, in terms of organization, with your question? Thank you. Let's break those two out. The first one is the question about prisons. So who would like to address the prison context?
I would say two things. I mean, it's true we don't have a calculated cost, but, you know, the state of Ohio's defense was, you know, we have a chaplaincy office. Those things I mean, they're very explicit about it. Those things we want to accommodate. In Cutter and Wilkinson. Those things we can accommodate, or, you know, there was actual testimony about what they thought and which groups got accommodated and which didn't. So the question of cost is true, but there was a real equality claim underlying it. It's inherent in the fact you have, let's say, 4 or 5 chaplains in a prison, and if you're from some other faith, nobody takes care of you, and particularly if you're an unpopular faith, and the record in that case was pretty clear, then didn't pay any attention to you in Ohio. I would say that your question illustrates precisely my last point. You phrased your question in terms of equality. And in the prison context, while equality is certainly an important principle, there are also liberty constraints, regardless of equality, which need to be taken into account. So to frame the question solely in terms of equality is to rephrase the question. As to zoning, I don't believe it's an accurate statement of the law that the government is under an obligation when it puts something unpopular or that hurts the value of your property next to you. There may be municipalities or in states that do it. I don't believe they're constitutionally required to do so.
And I guess I take it that, and either to Doug or Marcy perhaps on this one, about whether the current either litigation or maybe even the legislation in figuring out what it means to have a compelling interest doesn't formalize the weight that should be given to the cost imposed on neighbors. We can institutionalize the cost imposed on the city, and the city can figure out what its own. But the difference, it seems to me, with RLUIPA compared to lots of other accommodations is that because it is about locality, not just in terms of cities, but in terms of specific pieces of property, the costs are not spread across the entire community, the benefits. The costs tend to be much more localized compared to an exemption from military conscription.
Right. Now, I mean, there are cases in which the government is making the argument that there's a compelling interest in protecting property values for those in the residential neighborhood affected, but no court has yet found that that's a compelling interest, and it's never the least restrictive means. And so the standard is geared in order to create very difficult situations for particular individuals. It's just the way it has worked out. I honestly don't know what the answer is except to exclude residential neighborhoods from the impact of RLUIPA, which I think makes a tremendous amount of sense. And I could line up 100 people to testify on that in about 2 hours. But I would imagine that would be unpopular with the religious groups because the reason residential neighborhoods are so popular is because they're less expensive. And so you buy the property in the residential neighborhood on the assumption you'll get the zoning change. And then you didn't have to spend the money in the commercial district, which would have been more expensive. You get the financial deal, so you want to be able to keep RLUIPA in those circumstances. So it's complicated, but I think the takings jurisprudence is such that you'd have to completely devalue all of the value of the property to have any kind of takings equivalence. So I don't think that analysis really works, but I have thought about, is there a way to exempt the individual homeowners from having to be impacted by RLUIPA?
Well, I mean, the claim of compelling interest in most of these cases is about, the claim of compelling interest is about the burden on the neighbors, and that's where it gets litigated, and at some level of burden that becomes compelling. The cases I read, I don't see many that seem very close, right? There's an enormous sense of entitlement in these suburban neighborhoods. They own not only their own land, but they own all the land around them as far as they can see, and then control whatever happens on it. And I think that's a crazy way to run a regime of property rights, but that's the regime we have, fair enough. It is fundamentally incompatible with First Amendment activities. Right? This is like a form of standardless licensing. If the neighbors don't like what you're doing, you don't get to have a place of worship. If there's another place in the community, fine. If there's another place readily available in the community, the church ain't going to be spending tons of money filing this lawsuit, right? and of course there are bad claims that shouldn't be filed, but these are mostly cases where there is not a readily available place anywhere else in the community. And when the burden on the neighbors becomes becomes great enough, the zoning gets upheld and the RLUIPA claim loses. And there are plenty of them that lose. Plenty of them where the court finds no burden on the church. Fewer where they find compelling interest, but I think it's just easier to dismiss for dismiss for lack of burden. But you simply cannot give the neighbors a veto over other people's exercise of the right of the First Amendment on neighboring properties that those neighbors don't own.
That's completely inconsistent with what master plans and land use are all about. There are sections of cities that are designated for certain uses that are compatible, and you try to bring compatible uses together, and you put incompatible uses at far. So you don't put a prison next to an elementary school. I mean, it's just fundamental land use. That's not crazy. That's the way it works.
It's not the way it works, Marcy. You can't put it in a commercial zone either. You can't put it in an industrial zone.
Hang on. Tell me one town that does that. You always say that, Doug, every time. You can't show me a town that does both the commercial exclusion and the residential exclusion. You can show me cases in one or the other. It's not true in any jurisdiction in the United States that religious uses are not welcome. We have millions of churches. So the notion that you got towns that are like, well, you can't be here and you can't be here, it's just false.
Marcy,
House
let me go
of worship is
to
standard.
Mark for a second and the next question.
Marcy said that churches go to residential areas because it's cheaper. It's often not true. But the real reason why the reason why they go to residential neighborhoods is that's where the worshipers are. And they want to be close to their church because they go 3 times a week. And they're not going to get into their car and drive half an hour. Whatever the burden is, however that gets factored in, one ought not to just assume this is a purely dollars and cents consideration.
Next question. Is there somebody out there? Thank you.
While he's going to the microphone, in terms of the dollars and cents, just one of my favorites is Belmont, Massachusetts, where Mormon Temple was built in a residential neighborhood of professors from MIT. And the professors had lived there for 30 years, and they did not want a humongous temple with 350 parking spaces in their neighborhood. And the response from the temple was, don't worry, our members will buy your property. You can move, and we will all be happy. So, let's not paint just the one side as having goodwill or bad will. There are all sorts of things religious entities say that are offensive to landowners, and that is not an uncommon statement at all.
Thank you.
I've heard it in many cases.
Next question, please. Roman, could you take this?
Yeah, I think there certainly is a rise in those cases. Oftentimes, the religious organization will back down after they realize they're not wanted in the community. That applies to Muslims and to other minority faith groups. And the actual number of times it's litigated probably as few as it is with any one particular faith or denomination. With respect as just simply an empirical matter, I think that all of the instances I've seen involve hostility and discrimination against that particular faith group. And again, when we're talking about a situation like in New Jersey, where the town decides that they have to, for the very first time in their history, take property to create open space for its citizens, there's the fig leaf of some sort of neutral and generally applicable land use interests, but everybody knows what that regulation is all about.
Next question, please.
Bob Ritter with the American Humanist Association. I believe our association was one of the groups 20 years ago that may have supported this, but have since changed our position. And the reason for that is, under the Establishment Clause, government may not prefer one religion over another or religion over non-religion. And our view is that our RLUIPA and RFRA both favor religion over non-religion. I was wondering if any of the panel could touch on that subject.
So I think if we want to focus specifically on the land use part, whether there, because Cutter and Wilkinson, I take it, has put to rest questions about the prison part of our RLUIPA in terms of the Establishment Clause problems. One can think it's a preference, but I take that as settled law. We don't have settled law on the land use provisions, and specifically about the substantial burden, compelling interest aspect of land use. So Doug and then Marcy perhaps and others on that specific question?
Well, I don't think the Establishment Clause issue is substantially different on the land use side than it is on the prison side. And the court, the court thinks there is an Establishment Clause problem if an exemption imposes substantial cost on someone else, and that's at the heart of the argument Marcy and I are having. It thinks there's an Establishment Clause problem if you single out some religions for protection and omit others, but doesn't think there's an Establishment Clause problem if you give protection or exemptions to religious organizations and not to secular organizations. It's been unanimous on that 3 different times. I think a meeting house for the American Humanist Association ought to be protected by RLUIPA, but that's a tough sell to judges. They do it in tax exemption cases. I'm not aware of any RLUIPA cases.
Cutter v. Wilkinson is a case which is very specific to prisons, as the court's quite clear in the case when they twice say that they are not reaching the land use issue. That's partly because actually I filed the only brief talking about land use, amicus brief in that case, and I said it's radically different. Please do not pre-decide land use based on prisons. And the court actually both exempted it, but they also made very important points that prisons are so unusual because the question is not where you worship, which is the land use issue. It's whether you worship at all. And in the context of that kind of serious deprivation of any kind of religious exercise whatsoever, there's no Establishment Clause problem. But the court then went on to say, but of course we're going to have due deference to prison authorities. They watered down the test and all sorts of things. That land use is different. I do think there's an Establishment Clause problem. The notion that a theater is going to be treated differently from a religious land owner situation is crazy. They're both similar, as we've had many religious land use cases getting the benefits that a theater would get. But I think it flips around as well. What happens when the religious group has RLUIPA in the residential neighborhood or in the commercial area, and other uses do not, that are also assembly uses? I think there's a very good argument that this is just a simple privilege for religion in those circumstances. Having said that, I don't see a lot of challenges on Establishment Clause. Of course, no court held RFRA unconstitutional in the courts of appeals before it was held unconstitutional at the Supreme Court. So that game is definitely not over. And we still have quite a bit of debate on its constitutionality. But I think that for the moment, the courts are going to continue to focus on substantial burden, equal terms, and they're just starting to get to the edges of compelling interest. So we may be years away from that kind of a challenge, but it's definitely there.
I think I was writing the petition for a hearing in Smith when Steve Shapiro of the ACLU put Chris Eisgruber, then of NYU, on the phone and said, you know, I have this Establishment Clause theory about accommodation, and he spells out the theory that you just listed in your question. And I listened and I said, but I'm not a law professor. I'm merely a practicing lawyer. And I rattled off 4 or 5 cases in which the Supreme Court had rejected precisely that claim, that accommodation of religion was an establishment of religion. And he said to me, that's a problem with my theory. And I said, but I'm just a practicing lawyer and I'm writing a brief in the Supreme Court. That will have to do. And Smith is completely explicit about this. There's no mincing words here. Scalia said, no, we're not going to require it. We're also going to uphold it. It is true that in Caldor, as Doug was alluding to before, there is some outer limit to how far accommodation can impose burdens on other. We don't have any idea, vintage Justice Warren Burger opinion, we have no idea of what he had in mind. But it seems to me pretty clear that the sort of diffuse burden that citing a church, even in a residential area, and fortiori citing it in a commercial area, doesn't come anywhere close, particularly, as Doug has emphasized repeatedly, this is core First Amendment activity, without which the activity just doesn't take place at all. You really, it's silly to say that if you move a church 50 miles, there's the exercise of religion. People just don't drive 50 miles to go to church. And certainly, that is saying that Orthodox Jews can't move into a lot of communities. We simply can't drive, and you're telling us we can't worship. And I don't think that's going to be an establishment clause case.
I wonder about the continuing significance of Texas Monthly against Bullock, and whether there is if there is in fact a material benefit in terms of land. I have no idea, and this is a law professor like Chris Eisgruber speaking, rather than.
We'll forgive you for that sense.
But I just wonder whether there may be enough differences between the land use and the prison context to suggest that it would not be a unanimous decision. I don't have any idea.
It might not. Look, in the prison context, you have Justice Stevens' point about equality. Now, we think, Doug and I think, and others think, that there's a fair amount of inequality under the table in zoning as well. But if you had a case which was not an equality case, you could demonstrate was not an equality case, but was purely a liberty case, and you had a really significant burden on homeowners, that might be distinguishable.
Okay.
And we'd have to argue about that case. But so far, I haven't seen anything like that case. Doug is quite correct. Nobody has a vested interest in his community remaining zoned and populated the way it is when they move in.
Great, thanks. Kara, I think it's 2:30. Should we? One more question? Okay, one more question. Thank you.
One of the questions is a comment, it's a perspective from a person who's not a lawyer, who's not a theologist, but somebody who's seen this thing in the community. And I agree with Mr. Stern that in many cases, in most cases, to build a mosque, and a Muslim perspective, a Muslim building a mosque in a residential area is sometimes more expensive than building it in a non-residential area. But the other thing that you have to consider from a Muslim perspective is that Muslims have to pray 5 times a day. Now, if they do not have a mosque in the vicinity where they work or they live, it is very difficult for them to commute to a long-distance, mosque to pray. So it just defeats the purpose. So it is imperative that they have these facilities close by. So having them in residential areas as well as in commercial areas is extremely critical. And with all due respect, Professor Hamilton, I disagree with you when you say that that defeats the purpose. Thank you.
Any of you all want to respond, or do you want to close?
I've never seen a dispute that involved 50 miles. I'll just put it at that. Almost all these disputes involve relocating a mile or a mile and a half. Suffern, New York is the best example of that.
Okay.
Your Connecticut case involved moving halfway across the state of Connecticut to a little town that nobody's ever heard of.
In the New Milford case?
The New Milford case meant moving from New Milford to Moodus, Connecticut. which
No,
I
it
happen to
didn't.
be the
Okay.
only
No,
lawyer
it
in the
didn't.
country.
That's ridiculous.
It is now 2:33.
Unbelievable.
I have to
That
thank
is
Kara
a
Stein
joke.
for moving to the ASC so I could have a position at the American Jewish Committee.
I want to please join me in thanking our panelists.